Hi, I'm Tom Giannotti, attorney with the Butler Law Firm. Today I want to talk about an issue that is a sensitive subject for many folks, and that is the issue of abortion rights. It's in the news a lot lately because of the Supreme Court's ruling last week in the case of Whole Women's Health versus Jackson, which, as you may know, involved a Texas state law that was really unique in the sense that instead of relying on government officials to enforce the law, it essentially deputized private citizens and by allowing those citizens to bring civil lawsuits seeking money damages and against people involved in performing abortions. If two things were true: one, it was not a medical emergency, and two, the fetus had a detectable heartbeat, which the court has noted that occurs roughly 6 weeks into a pregnancy. Now, there is a provision in that state law that would allow an abortion provider to defend themselves by showing that holding them liable would place an undue burden on women seeking abortions, and that has to do with the court's landmark ruling in Planned Parenthood versus Casey. But this particular case, which I have pulled up here, this is the decision from December 10th, last Friday, that the decision really did not involve the merits of whether this is constitutional or not. This case involved essentially the question of when a challenger is bringing what happened here, which is a pre-enforcement challenge, which government officials do they bring that? Do they bring that against the Texas Attorney General? Do they bring that against the state licensing board? Do they bring that against, or can they bring that against state court judges and clerks of court? So as to the latter, the court said no, and as to the Texas Attorney General, the court said no. Now, the court did allow the lawsuits to proceed, the challenges to proceed against the Texas state licensing officials. So, and actually 8 of the 9 justices on the court agreed that that the abortion providers could bring a pre-enforcement challenge against the state licensing officials. But the court held that, as is the case in many other areas of the law, that the state court clerks and judges and also the Attorney General, but for different reasons, enjoyed official immunity or government immunity from these suits and could not be sued by people trying to challenge this law. So again, what the court did not do is the court did not overturn Roe versus Wade, and the court did not address whether this Texas state law was constitutional or unconstitutional. The court just addressed whether and against whom and these challenges can be brought. So what that means effectively is that this Texas state law remains in place, and what we'll have to wait for to see what the court is going to do with abortion rights is another case called Dobbs versus Jackson Women's Health Organization. And that case involves a Mississippi state law. And the Mississippi state law has banned abortions after 15 weeks into the pregnancy, except in medical emergencies and other rare circumstances. So in this case, as you can see on the screen behind me, it does appear that there has been a shift in the positions of the newer justices in the court, given the shift in the composition of the court in recent years. That it is possible that the court will limit the right to abortion or possibly even overturn Roe versus Wade. So while the court did not do that in the Texas case, in this Mississippi case, it's possible that the court will overturn Roe v. Wade? Yes. However, the court, if it were to do that, would really need to explain why it would be suddenly departing from the principle of stare decisis. In other words, departing from its own precedent, particularly where the court has in previous years noted that women have come to rely on this particular precedent in allowing the right to abortion. So what is the court likely to do? My guess is as good as yours. I don't know and I can't speculate, but during the oral arguments, several of the justices expressed some concerns with the public perception of the court as being a political institution, which it's not supposed to be. The Justices Sotomayor and Justice Kagan had expressed some grave concerns with the public perception of the court as an institution that is insulated from political pressure and the importance of the rule of law and upholding confidence in the judiciary, whereas other justices, such as Justice Kavanaugh, had questioned, well, the court has overturned its own precedent in other areas of the law, why not this one too? So that gives us a little bit of clues as to what the court may do, but it's tough to read too much into this. So here's what Justice Kavanaugh had said. He said that basically the court has done this in many other circumstances, that why not, how is this different? And again, when the justices pose these questions to the lawyers arguing the cases, they're often posing these hypotheticals, and it doesn't necessarily mean that they agree with the sort of inference from that hypothetical, but again, it would seem to suggest that perhaps Justice Kavanaugh is more inclined to overturn or limit Roe versus Wade than perhaps Chief Justice Roberts, for example. So again, Justice Sotomayor had noted that this Mississippi state law was drafted in a direct response to changes in the court's composition, saying that if the court were to overturn Roe versus Wade, the public would see this as an overtly political act, essentially. That it would just set a bad precedent, essentially. That the whole point of stare decisis is to prevent people from thinking that this is a political institution and uphold the legitimacy of the court, and pointed out, and Justice Kagan pointed out that not a lot has changed aside from maybe the court's composition since Roe versus Wade and since Planned Parenthood versus Casey in those several decades. And Justices Gorsuch and Barrett also had expressed some hesitation about Roe versus Wade and the rights to abortion that had a lot of people watching them very closely, because as we saw in the Texas case, even if Chief Justice Roberts, who has been the swing vote in a lot of other landmark decisions, if Chief Justice Roberts joined the other traditionally more liberal justices like Justice Kagan, Justice Sotomayor, and Justice Breyer, that they're essentially in a minority on this particular issue, and that if the majority of the justices, which have been regarded by many as quote more conservative, were to vote essentially to overrule Roe versus Wade, that would be within their power to do so. So we'll have to wait until next summer, most likely, to get a ruling from the court on this. But again, at least one of the other justices, such as Justice Barrett or Justice Gorsuch, would have to join the other justices to form a majority and leave Roe versus Wade and Planned Parenthood versus Casey intact. So we will leave it at that, and I look forward to doing more of these videos talking about these current events. Thank you for watching.